gross negligence manslaughter is a form of involuntary manslaughter where the defendant is ostensibly acting lawfully. Involuntary manslaughter may arise where the defendant has caused death, but neither intended to cause death nor intended to cause serious bodily harm and thus lacks the mens rea of murder. Whereas constructive manslaughter exists where the defendant commits an unlawful act which results in death, gross negligence manslaughter is not dependent on demonstrating an unlawful act has been committed. Gross negligence manslaughter can be said to apply where the defendant commits a lawful act in such a way as to render the actions criminal. Gross negligence manslaughter also differs from constructive manslaughter in that it can be committed by an omission. The leading case on gross negligence manslaughter is the decision of the House of Lords in R.v. Adomako. It was held that the law on reckless manslaughter, as stated in R.v. Seymour, should no longer apply. In R.v. Adomako, 1994, the appellant was an anaesthetist in charge of a patient undergoing surgery. During the operation, an oxygen pipe became disconnected and the patient died. The appellant failed to notice or respond to obvious signs of disconnection. His conviction for gross negligence manslaughter was upheld. The Lord Chancellor, Lord Mackay, set the requirements for gross negligence manslaughter. The prosecution must establish that the defendant, 1. owed a duty of care, 2. was in breach of that duty, 3. the breach of duty caused death, and 4. the conduct of the defendant was so bad as to amount to a criminal act or omission. The case of AG Ref No. 2 of 1999 confirmed that R.v. Adomako required no proof of mens rea on behalf of the defendant. This means there is no requirement for the defendant to even foresee death as a possible consequence of their conduct. This was affirmed in RVD-PP ex parte Jones, 2000. It was ruled that the CPS were wrong to base a decision not to prosecute on the lack of subjective recklessness of the employer. Lord Mackay, in R.v. Adomako, made it clear that civil law concepts of duty of care should apply in deciding the criminal liability of a person for gross negligence manslaughter. This has proved problematic outside the realm of medical negligence and driving cases. In particular, the imposition of a duty of care on a drug dealer to one whom he has supplied seems to be illogical. However, the courts have stated a duty can arise in such circumstances. This was seen in R.v. Khan and Khan, 1998. Two brothers were liable for gross negligence manslaughter where they supplied heroin to a 15-year-old girl at their flat. She started to show signs of overdose and they left her. When they returned, she was dead. A duty of care arose for their failure to summon help, as they had created the dangerous situation which caused her death. Similarly, in R.v. Evans, a woman who supplied drugs to her sister was held to owe a duty of care to summon help for her when she displayed symptoms of an overdose. The duty arose not from her familial relationship, nor from her acceptance of duty, but through her supplying the drugs and thus creating a dangerous situation. In addition, it has been held in R.v. Wacker that the defense of ex turpi causa, which operates in civil law to negate a duty of care where the victim is acting illegally, has no application in criminal law. The defendant was liable for the deaths of the illegal immigrants that had suffocated in his lorry. The application of this principle was also seen in R.v. Willoughby. The defendant was liable for the death of the man that he had paid to set fire to his pub in order to claim on the insurance. One problem of the Adomako test relates to the circularity of the test. That is, the jury are to find the defendant liable of a crime, if they thought his actions amounted to a crime. This was challenged in R.v. Misra and Srivastava, 2005, as being in breach of Article 6 and 7 of the European Convention of Human Rights. However, the Court of Appeal held that the test was sufficiently certain to comply with convention rights. In summary, the law relating to gross negligence manslaughter was established in R.v. Adomako. To incur liability, the defendant must owe a duty of care and breach that duty resulting in death. The jury must be satisfied that the defendant's conduct was so bad as to amount to a crime. Gross negligence manslaughter may be committed by an omission. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.